Good afternoon. I'm going to wait just a few more moments to make sure that everyone is fully connected before we get started. All right, it looks to me like everyone is able to join and is online. So I'm going to go ahead and get this started. It is 1:02 p.m. Good afternoon. I am Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. I'm going to go ahead and give a brief introduction about this proceeding. We'll then move to a roll call and we'll identify those who will be participating in the pre-hearing conference today. And then I will move on to the purposes of this pre-hearing conference. So please bear with me for this introductory part. This is a pre-hearing conference for the public hearing on the proposed revocation of public water system permit number 2018-03-017, issued to Bloomingcamp Water System. This pre-hearing conference is being held in accordance with the notice of hearing and pre-hearing conference dated December 30th, 2022 that was issued by my office. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and the video are being recorded, and we will post files of this recording along with the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If at any time you are experiencing technical difficulties trying to communicate with us during this pre-hearing conference, please send an email to the AHO. That is at admin.hrgoffice@waterboards.ca.gov. Members of the AHO staff are monitoring that email inbox and they can alert me if there are any technical difficulties. Assisting me today are several staff of the Administrative Hearings Office. I have Nicole Mullen and Amy Blunk. I also have attorneys David Rice and Zach Miller from the board's Office of Chief Counsel. I'm also joined by Kurt Souza from the Division of Drinking Water. In addition, I have also Skylar Anderson and Kyle Woldridge from the AHO office as well. At this point, I would like to go ahead and move to appearances. To do that, I'm going to identify the parties to the proceeding. And if you are representing that party, if you would please unmute your microphone, and ideally, if you're able, enable your video so we can see you and state your name. As we proceed, if you are able to keep your microphone muted except when you're speaking, that's very helpful to minimize background noise and other distractions. And as I mentioned, if possible, please enable your camera when you're speaking so that we can all see each other as we participate in this conference. So I'll go ahead and start with the prosecution team for the State Water Board. If you would please identify yourselves if you will be participating in the pre-hearing conference today.
Sure, I'll get started. Good afternoon. My name is Heather Jidkoff. I am an attorney in the State Water Board Office of Enforcement, and I represent the Division of Drinking Water prosecution team on this matter.
Thank you. Good afternoon, Ms. Jidkoff. And are there other members of the prosecution team who will be speaking and participating today who should be introduced?
I'm not aware that any of the other members of the prosecution team are intending to speak, but if you would prefer, they can go ahead and do introductions in the event that something comes up that they do need to address.
Why don't we just do it this way? Thank you for introducing yourself. And if anyone does end up participating, we will make sure to get their name and introduction for the record. That would be great. I'd appreciate that.
That sounds good.
So from there, I'll go ahead and move to Bloomingcamp Water System, who I understand is represented by Matthew Steinberg. Are you joining us today, Mr. Steinberg?
I am here.
I see you. Thank you.
In addition, Matthew Emmerich is our counsel, and Cooper Condit will also join. Unable to attend today is Reed Johnson. Reed is our water engineer. If possible, I would like to make about a 2-minute opening statement.
Let me, thank you, Mr. Steinberg. I appreciate the introduction. Let me make sure if I can, I'm going to get introductions directly from the other parties, the other
Yes.
individuals you mentioned, and we'll
Yes.
get through that. And I certainly will give you an opportunity to say what you need to say before we get too far into this. So thank you for
Thank
letting
you.
me. So I understand, is it Mr. Emmerich is also here joining us representing Mr. Steinberg and or the Bloomingcamp water system. Mr. Emmerich,
Yes.
if you're here, if I see
Can-
you and I see
Can
you
see-
have,
can you hear me?
I can hear you as well, though if you could speak a little louder, I think it's somewhat, you may not be close enough to the microphone.
Okay. Matthew Emmerich for Bloomingcamp water system. I will be assisting the system during the hearing process.
Thank you, Mr. Emmerich. And we have, this doesn't have to be formal, but if you would, at your convenience, maybe send an email to the Administrative Hearings Office identifying yourself and the contact information that you would like so that we can add you to our service list for this proceeding, that would be very helpful.
I will
And
do that.
that's that email I mentioned, admin HRG office@waterboards.ca.gov. Thank you very much.
Thank you.
And was there another individual, I think you mentioned Mr. Steinberg, who is also maybe participating
Yes.
today on behalf of the water system?
Yes, that's Cooper Condit. He's on a dial-in line.
Mr. Condit, I understand we may not have a visual, but if you wouldn't mind just speaking up so we can hear your voice and identify your dial-in number, which I think I see here. Mr. Condit, it looks like you may be muted. Let's see. I'm going to ask you to unmute, see if that works.
Can you hear me?
I can now hear you. Thank you very much. If you could just go ahead and
Great.
state your name for the record, that would be very helpful.
My name's Cooper Condit, and I'm the district director for State Assemblyman Heath Flora.
Thank you very much. And thank you for joining us. And then Mr. Steinberg, I think you also mentioned that Reed Johnson will be participating possibly in the hearing, but was unable to join us today. Is that a correct understanding?
Yes, that's correct.
Thank you. And I will just repeat to all of you, if you would like to be, anyone who's participating today, if you would like to be added to the service list for this proceeding, please just send an email to the AHO identifying the contact information that you would like to be used, and we can add you to the service list so that when we send out any emails, those would go directly to all of you. And also if the parties are emailing each other, we ask that you include the entire service list so that keeps everyone informed. Just as a side note, I think it's appropriate, I had it later in my script, but I think it's appropriate to say now, the AHO uses an FTP site to maintain our administrative record for these types of hearings and proceedings. So we have a folder that is publicly available that contains the administrative record for this proceeding. It includes all of the documents that have been circulated related to the Bloomingcamp water system in this hearing. It includes the hearing notice. It also includes PDF copies of all of the emails that the hearings office has received related to this proceeding. So that is a way to easily access all of those documents. To obtain access to the AHO FTP site, you do need a password. It's publicly available, but you do need a password. So once again, if you email our office and ask for the password to access the AHO FTP site, we will send you that password, and then you'll be able to access the folder for all our proceedings, but including this proceeding as well. That is the location where we'll be posting copies of the video of this proceeding and the recording. We also include the Zoom generated transcript, although it's a little, sometimes the quality isn't great, but it's something, and it's often useful to find the relevant sections. I think with that, I would like to thank you. I guess I'll pause and ask is there anyone else who plans on participating today who has not already had a chance to introduce themselves? This would be a good opportunity to speak up. All right. Thank you very much. I think I'll briefly go into the purpose of this pre-hearing conference, and then I'll turn back to you, Mr. Steinberg, if you have some comments you would like to make.
Thank you.
My view of this, the purpose of this pre-hearing conference is to address any procedural issues or questions concerning the hearing that any of the parties may have. I want to address the issues raised by Mr. Steinberg in his email of January 11th. I did read that email carefully, and I'm have it actually in front of me. And I also want to address any other questions that you may have, Mr. Steinberg, or that your council may have about this proceeding. I know the AHO, it's a new office. We're setting our procedures in place, and this is actually the first drinking water matter we've run through this office. So I understand there may be questions from all sides, including the prosecution team. And I just wanted to raise the caveat that this pre-hearing conference is not the time to discuss the substance of the issues that's before the Administrative Hearings Office at this time. It is not a time to present evidence or make legal arguments about those substantive issues. It really is a time for us to talk about the procedures that are going to apply to the hearing and any processes that might occur leading up to the hearing. My vision of how this would go is I know there's some outstanding issues about my participation as the hearing officer in this proceeding. I certainly want to talk about that today. I then want to step through some of the other issues raised by Mr. Steinberg, and then lastly, walk through the hearings process just to make sure there aren't any questions and to address any questions as they come up. And then I'll look to the room to see if there are any other issues that we should talk about. Just as a general matter of process, as we work through and discuss these issues, I'm going to ask for input from both the prosecution team and from you, Mr. Steinberg, and your counsel. So you will certainly have the opportunity to speak on all of these issues. We just will take our time and work through these and hear what both parties have to say. I think now, with all that said, now would be a good time, Mr. Steinberg. I know you had some comments that you wanted to make, I think the general comments. So if you'd like to make those now, you'll certainly have a chance to speak on the specific issues we talk about through this conference. But if you would like to make some general comments now, the floor is yours and you're welcome to do that.
Yes. So first, Nicole, thank you. And thank you for hosting this. I think it's important that you have some background and you get the view of the other party here that's part of this. So before I engaged Reed, I was told by a water engineer, and I quote, "Systems like yours are unusually difficult to address, not because of the complexity of the contaminant, but because regulations require a level of effort to achieve compliance that is costly. Unfortunately, the regs don't differentiate between a small business like yours and a multi-million-dollar manufacturing operations." Because of this, we had asked the county, Stanislaus County, who was operating under an LPA from the water board, quote, "Please indicate any person on the county or SWRCB staff who could be interested in discussing creative ways or alternative technologies with us that small water systems can afford that allow small water systems to become compliant with water quality standards." Okay? So we'd asked this early on in the process. However, not once did either party, DER or the water board, take us up on the offer. We had to wait until a correspondence on December 30th of 2022, where the water board said, the quote, "The prosecution team and the respondent may engage in private settlement discussions." So about 4 years later, we got a response. The prosecution team indicated back to us its willingness to participate in the settlement negotiations. And my team have responded to that, to the water board or the prosecution team, with a proposed date for those settlement discussions. So we are pleased with that development. Now, we move forward with the installation of the point of use treatment on the direction of the director of Stanislaus County Department of Environmental Resources. And these units were installed by the manufacturer. Okay. Now, why are we here today? Well, we get a general statement from the water board that says quote, the treatment installed for Bloomingcamp water system does not comply with the point of use regulations. That may be true. That's certainly the point of view that the water board's taken, but this statement doesn't provide sufficient information for us to determine what's out of compliance and what remedy may be in place. So in preparation for the settlement conference, I've asked the prosecution team to provide the following. First is to identify the specific reasons why it is moving to revoke Bloomingcamp water system permit, and to provide the technical reasons why our approach is unsatisfactory. So it's important that we understand what the technical reasons are. Second, we've asked for the settlement conference to be identified specific items that we will need to address in the settlement conference, right? We need to be able to properly prepare and then in order to enter in this conference. That's the background I'd like to provide. In addition to my comments, if you see fit, I'd like to ask for you to allow comments from Cooper Condit.
Thank you, Mr. Steinberg. I appreciate that. And if there are, I think this is a good time, Mr. Condit, if you would like to make any additional comments that you think are relevant, general comments, you are welcome to at this time.
Well, just a backstory from my point of view. Our office, Assemblyman Flora's office, has been working with Bloomingcamp Ranch since, I believe, 2018, 2019, in addressing this and trying to help them navigate this overwhelming bureaucracy from the county and the state. We've tried to get them resources with the Valley Water Collaborative, which is a resource that's supposed to be there to help folks who, are out of compliance. But since Bloomingcamp Ranch had a corrective action against them, they were unable to receive that resource, which I think is really a catch-22. But we've been there. We've helped gather support from numerous elected officials, such as Congressman Josh Harder, former state senators Galgiani and Andreas Borges, Assemblyman Flora, Assemblyman Adam Gray, the county board of supervisor for that area, Kristen Olson, and numerous other local elected officials, and also small businesses in the Oakdale area. So I would just hope that everyone takes that into account, that we don't want to see broad brushes penalize small businesses that are doing their best to comply with these regulations.
Thank you, Mr. Condit. I guess I think what I'll do, Mr. Emmerich, did you have anything that you wanted to add at this time, or can we move on? I'm going to turn next to the prosecution team for any general comments. Mr. Emmerich?
I don't have any statement at this time. I'm primarily paying attention to the procedure. Thank you.
Thank you. I appreciate that. In fairness, Ms. Jidkoff, I want to give you a chance if you had anything general you'd like to say before we jump into some of the specific issues to address today. Is there anything you'd like to add at this time?
I would just note that many of the issues raised by Mr. Steinberg are substantive in nature and do exceed the scope of today's pre-hearing conference, which is only intended to address procedural issues or questions. So to the extent that there are substantive issues that the prosecution team would otherwise provide in response to Mr. Steinberg's points, we will do so in the context of the hearing or in the context of settlement discussions. And I do want to note that for purposes of our settlement discussions, Mr. Steinberg, you did note some of the items that you've requested of the prosecution team. And moving forward, I do want to note that any information exchanged in that context should be kept confidential in accordance with Evidence Code sections 1152 and 1154. So we should not be discussing any settlement communications before hearing officer Kenzie.
Thank you, Ms. Jitkoff. I appreciate that. At this point, I'd like to turn to some of the specific procedural issues that I had identified that I know what we want to talk about. I did want to start with one of the big ones, which is the question of whether or not I should recuse myself from the role of hearing officer in this proceeding based on my professional relationship with Ms. Laura Mooney, who I understand is intended to participate in representing the prosecution team in this proceeding. I sent an email to the parties on January 9th that described the facts of my relationship with Ms. Mooney, which included a professor-student relationship that occurred, at this point, it's over 2.5 years ago. And I also served as an employment reference for Ms. Mooney. I recall it as this fall. I didn't have specific dates, but I think the prosecution team, in your pre-hearing conference statement, suggested August. That may have occurred in August of 2022, and that sounds correct to me. I don't intend today to make a final decision about my voluntary recusal. I do want to hear from the parties on this issue. Although I want to say that I did read the pre-hearing conference statement from the prosecution team dated January 20th. I received Mr. Steinberg's email on January 11th. So I have all of that information. To provide a little more background on my point of view and where I'm coming from on this, as I noted in my email to the parties, this issue is complicated by the fact that the AHO, that's the Administrative Hearings Office, currently doesn't have any other hearing officers who are available to take on new matters. And this is just a matter of our staffing. We have a retirement, we have a hearing officer on leave. So I am the only one at this time. So I can't just reassign this matter, which I think otherwise would have been a really preferable and simple solution, and we would have gone forward without much discussion. I also indicated in my email that the facts that I do not believe it's my conclusion that the facts here require my disqualification by law or to satisfy due process. I have no doubt that I could serve as an impartial decision maker in this proceeding. My relationship with Ms. Mooney was professional and was relatively limited. It was limited to my relationship with her as her professor and then providing a reference for purposes of employment. However, I'm thinking of the larger role of the Administrative Hearings Office, and I do think it's appropriate for the AHO to set a standard in some that is above and beyond what the law requires in terms of a minimum for due process and with respect to appearances of partiality. That's a very important issue for this office and this institution. I also had been thinking about this matter in terms of involving a party who was not represented by legal counsel. I'm encouraged that Mr. Emmerich, you are providing some support in that capacity. But I also want to see this matter really focused on the issues identified in the hearing notice, on the potential public health issues and considerations related to the Bloomingcamp water system. And I don't want to see this distraction of what I call a peripheral procedural issue. It's in everyone's best interest for us to stay focused. So those are the considerations that I have in mind right now. I do want to clarify for purposes of the prosecution team. I know you may also be thinking of this decision in a larger role in your continuing appearance before the AHO. I want to clarify that I think this is a case-by-case discretionary decision. Whatever my determination is here, I don't intend it to be precedential. I don't intend it to necessarily govern my involvement in future cases or the involvement of other hearing officers, or to apply as a general standard for the hearing officers in future cases. So I would intend that my decision be limited in that respect, and that it may be appropriate to make a decision here that wouldn't necessarily apply in other situations. I think with that, I would like to stop talking. I want to hear first, I believe, from Ms. Jidkoff from the prosecution team, and then I'll turn to you, Mr. Steinberg or Mr. Emmerich, as you see, or both of you, as you see fit, for anything you'd like to say on this topic that may be in addition to what you've already sent to me in writing. So, Ms. Jidkoff, you have the floor.
Thank you. I don't have anything additional to add, but I would just like to reiterate some of the key points from the written response that I provided. And that is that we do believe the relationship that you had with Ms. Mooney is distinguishable from a law clerk and a judge. But if there is a 1-year waiting period imposed, we would like it to be based on the date that Ms. Mooney concluded your course, since that's the substance of the relationship that you had with her. In the event that that date is calculated from the date that you acted as a reference for Ms. Mooney while she was applying to her current position, the prosecution team's preference moving forward would be to not delay the matter and to proceed to the hearing as scheduled on March 3rd. But we do want to be transparent and acknowledge that Ms. Mooney has been substantively involved in this case. And so to that end, we did ask for clarification on what Ms. Mooney's permissible level of involvement would be under alternative 2. The prosecution team is willing to agree that Ms. Mooney will not enter an appearance at the hearing on behalf of the prosecution team, but we would like confirmation on whether she is able to have any substantive involvement in the case, given that she already has had substantive involvement. That might make our preferred alternative no longer feasible and potentially require a new hearing officer, depending on the scope of her permissible involvement under that alternative. And I would just further reiterate our point on Mr. Steinberg's request for double recusal. If we can appropriately restrict Ms. Mooney's involvement on the matter and you can proceed as the hearing officer, that should address the concern of an appearance of impartiality. Alternatively, if the matter is assigned to another hearing officer, there wouldn't be that same concern of impartiality that would require Ms. Mooney to still be removed from the case before the new hearing officer.
Thank you. I appreciate those points. And you raised another question that I have. Can you speak to, please, Ms. Jidkoff, can you speak to I want a better understanding of the importance of moving this matter to a hearing in the near future rather than postponing possibly until June or July. I mean, I understand there's an interest probably by everyone to see this move forward and come to a conclusion, but are there any other considerations that you think I should be aware of in terms of the urgency of this proceeding in particular?
I don't want to go too deep into the substantive issues, but there are concerns that the prosecution team has about the quality of the water being provided at Bloomingcamp Ranch, given our position that the treatment is not installed in compliance with the regulations. And so part of the reason we would want to move forward is to not drag out the resolution of this matter in the instance that there is a risk to public health and safety.
Can I please address that, Nicole?
You will have, Mr. Steinberg, let me make sure I'm done with Ms. Jidkoff, and then you will certainly have an opportunity to address that. I think with that, I'm looking at my notes. Ms. Jidkoff, is there anything else you'd like to add at this time? We can always circle back if anything else comes up, but
no, not at this time. Thank you.
Okay. Thank you very much. So with that, I will turn to you, Mr. Steinberg. You're welcome to address certainly those most recent comments, as well as anything else you would like to for me to consider with respect to my decision as to whether to continue as the hearing officer in this proceeding or to reassign the matter.
Okay, I want to address the matter here. We don't see that there's any urgency into this. We are providing purified water that is well below the nitrate maximum contamination level that is set by the EPA. We have 7 buildings in question, 3 residences, a cider barn, 2 public restrooms, and a bake shop. The cider barn and the restrooms are less than 30 feet apart, but the physical run for plumbing is 60 feet. The plumbing the way that we have set up the cider barn and the 2 restrooms is per the manufacturer's instructions. And it's the same way that you would plumb a water treatment unit that sits underneath the sink in your refrigerator. It is supplying a faucet on your sink, and it is supplying your refrigerator, and we plumb things exactly the same way. So that we don't believe if you went to each of those faucets that you would find clean water that meets the MCL at each of those faucets.
Thank you, Mr. Steinberg. Is there anything else you would like to add? I read your email of January 11th about your concerns about a fair proceeding and my professional relationship with Ms. Mooney. Is there anything else that you would like to add or that you would like me to consider, or do you have any change to your position based on our discussion today as I consider how I should handle this part of the procedure? We seem to have lost your audio, Mr. Steinberg.
Sorry, I politely went on mute. I don't, Matt Emmerich, do you have any comments about the recusal?
I don't have anything online today, Matt. We can talk afterwards, but for the time being, I'll defer to your position.
Okay, my general position has been, Nicole, that we have asked for mediation. We didn't get a response. The water board is the water that sets the rules, interprets the rules, and enforces the rules. I don't know how there can be a sense of fairness when one agency gets to do all 3. That's just our feedback. Thank you.
Thank you, Mr. Steinberg. I can't resist, but that is exactly, Ms. Mooney's course was exactly on this issue. I teach administrative law. It is the puzzle of administrative agencies that all these functions are put into one agency. And then the question arises, how do we handle this matters where you have the decision maker and the prosecuting party within the same umbrella? The State Water Board has actually gone above and beyond what the law requires in setting up a separate office of enforcement so that those attorneys are separated from attorneys who would be advising the board. And then most recently, the legislature created just a few years ago this administrative hearings office so that hearings officers are separated out from the rest of the board, and we are intended to serve as impartial decision makers. So there is, I recognize the fundamental challenge with agencies that mix these various functions. I can assure you the board is doing our best to separate those out. Obviously, you go through this process, and then there is the chance for judicial review. That's always part of the process. With respect to my participation as the hearing officer, I think I will turn to you, Mr. Emmerich. I'm not going to put you on the spot. But once you've had a chance to consult with your client, and I would strongly suggest that you read the email that I wrote on the issue so you can understand more of the facts behind this. If Mr. Steinberg were to submit in writing that there was no concern about my participation as the hearing officer, then I got the same from the prosecution team, then I think I would be comfortable moving forward, because as I represented, I have no doubt that I could serve as an impartial decision maker. However, if the concerns continue, maybe what I'll ask or direct you to do, Mr. Emmerich, if I may, is ask if you would just clarify the position once you've had a chance to discuss with your client. Either you or Mr. Steinberg clarify your position so I understand whether this issue is still on the table and whether I need to address it. So
happy to do that.
Thank you. I appreciate that because it's important, and we want to do this right. And just so you know, I would anticipate that if another hearing officer were to be assigned, that this hearing would go forward either May, June, or July. That would be the estimate on when the postponement that we're talking about.
Thank you.
Mr. Steinberg, is there anything else you'd like to add on this issue at this time?
No, not this time. Thank you.
Thank you. And Ms. Jidkoff, I just will give you a chance. Is there something you'd like to say in response?
No, nothing at this time. Thank you.
Thank you. So I appreciate that. I will, of course, we all want to know when this hearing is happening. So I will certainly make a decision as soon as possible, but I will wait to hear from you, which I assume will be in a timely manner, Mr. Emmerich. I won't set a deadline. And then we can move forward on my issuing a final decision on whether or not I'll be serving as the hearing officer. Give me a moment. I'm looking through my script to see where we are. Oh, next I had noted down the possibility of settlement discussions. I am quite pleased that there are conversations, it sounds like, occurring or plan to occur between both parties. I always encourage these conversations. I often find that the process of scheduling a hearing in these matters sometimes helps the parties focus on settlement. So it's good you're having conversations. I appreciate the efforts on both sides. That I know it takes time to do that. Mr. Steinberg had raised some questions about access to information and documents, and they really, I think, were directed to the prosecution team for more information about the regulation of these types of systems or similar systems. I did want to identify for Mr. Steinberg that although normally we don't have a formal discovery process in these types of hearings, there is the Public Records Act. So you do, I just wanted to flag that for you, that you do have access to agency documents that are to the extent they're public records, and you can ask for those documents through the Public Records Act. Ideally, that process would occur directly through conversations with Ms. Jidkoff and her team. You would not need to go through the AHO. Those requests could be made directly. But if there are concerns about access to information or documents that you think affect your ability to represent your side of the story in this proceeding and put on evidence in this proceeding, then you can bring those to my attention. The best way would be by sending an email to the AHO and with a CC to the service list. We can always schedule another pre-hearing conference if that's appropriate to address that or any other issue that might come up in the meantime. Just on the note of settlement discussions, I appreciate your warning, Ms. Jidkoff, to Mr. Steinberg about the confidentiality of those discussions. So I'm not asking for substance, but Ms. Jidkoff, is there anything you want to comment on or note about settlement or about the timing of the settlement discussions with the hearing? Do you have anything to add on that topic?
No, nothing at this time. In terms of the timing of settlement and the hearing, I think we'll have a better idea how much time we may potentially have to discuss settlement once we have resolution on whether there's going to be recusal or whether the hearing is going to be postponed. But for now, I don't have anything to add.
Okay, thank you. And then I'll turn to you, Mr. Steinberg. Is there anything else? I know we've mentioned settlement a number of times, but is there anything else that you want to add or any other questions you may have about my comments about the Public Records Act or anything of that nature that you'd like to bring up? And now you're off mute. Please go ahead.
I don't, Matt, about gaining access to materials.
If there is a Public Records Act request, with the hearing in the first part of March, turnaround time, would we have those documents in time? Would we have those documents before we would present testimony and evidence, which I think is scheduled for the.
Oh, we just lost your audio, and you are not on mute, so I don't know why we lost your audio, Mr. Emmerich. Maybe. It may be a bad connection. I'm not sure.
I'm going to just translate. I won't put words into his mouth, but Since this is a Public Records Act request, what's the turnaround time that we would be able to get the documents? We have responses that are due, a couple of weeks before. And, was whatever the date in March is, will we have enough time for that?
Right.
That's correct.
Thank you, Mr. Emmerich, and you're back and we have audio on you as well. So thank you.
Yeah,
I think,
I just changed connections, so hopefully this one's stronger.
thank you. That is the type of thing I think that we would, if that becomes a problem, that would be the type of thing that would be appropriate to contact the AHO about. It may warrant, depending on the type of information that's being requested and its importance, that would be a consideration for whether the hearing should be postponed or some of the deadlines amended. So I think it depends on the nature of the specific request. I encourage you to work directly with the prosecution team on those requests as quickly as possible. But if there are issues that come up in terms of the turnaround time and sharing documents, I think those are appropriate to come to me or whoever the hearing officer may be to address. Does that respond? I know it's not a detailed response, but for now I'm going to leave the normal deadlines associated with the PRA in place and see if we can work through this voluntarily. Is there anything else you'd like to add, Mr. Emmerich?
Not at this time. Thank you.
Thank you. Mr. Steinberg, anything else before we move on to the next topic?
No, thank you.
Thank you. I think I would, very briefly, my intent was to walk through the process for the hearing. Whether or not I'm the hearing officer, the process will generally be the same. And I just wanted to flag a few important items and dates, and then I'll open up to see if there are any questions, to see if my comments trigger any questions. The first deadline that is set in the hearing notice is February 24th, which is a deadline for filing any exhibits or proposed testimony before the hearing, but it is an optional deadline. I'm not requiring testimony to be submitted in writing in advance, nor am I requiring those exhibits to be submitted in advance. But I find that doing so really streamlines the hearing process for both parties. It also allows my office to process those exhibits and make sure that they're available on the AHO FTP site, and then make sure that they're available to us as we run through the hearing. The general process in these hearings is that my team will handle the bringing up of exhibits, if appropriate, during testimony, if we want to take a look at those during the hearing. And it is very helpful to have those in advance so that we can just pull them up quickly. So I strongly encourage submitting that information by February 24th, if possible. But it is an optional deadline for both parties. It is not required. The hearing is scheduled right now for March 3rd to begin at 9 a.m. By Zoom. As I laid out in the hearing notice, the typical process is that each side would have 5 minutes for an opening statement. I generally would start with the prosecution team, and then Mr. Steinberg, either you or your representatives would have an opportunity to submit an opening statement. I have allowed each party 1 hour to present testimony, and that's total, including all witnesses who may be involved. After each witness has testified, there will be an opportunity for cross-examination. So, Mr. Steinberg, this hearing is your opportunity to present your evidence, your arguments, and also to ask questions of the prosecution team's witnesses. So each side will have an opportunity for cross-examination. I put a limit here of 60 minutes for cross-examination. That is discretionary. If I think we're making progress, I can allow more time. If I think we are repeating ourselves and not making any progress, I may allow less time. I do want to move these matters forward, but the hearing itself is an important opportunity for everyone to have a chance to ask these types of questions. So cross-examination is very important. I will, within my discretion, allow some redirect. So, for example, a witness testifies, the other party has an opportunity to cross-examine, and then the witness will have an opportunity to add any additional testimony that was related to the substance of the cross-examination. And that's within my discretion. And if it's appropriate, I may allow cross-examination on that redirect testimony. There's also an opportunity for questions from the hearing officer and the hearing team. So after each witness has testified, I may have questions and I will ask those. Normally I save them to the end. Sometimes I interrupt and ask them when they come up, but often I find cross-examination answers the questions I have. So I usually wait until the end. And then we go through this process of formally submitting the exhibits offered by the other side into, offered by each party into the evidentiary record. And that there is an opportunity to object to any of those exhibits if there are questions about whether it's appropriate, whether they're related to these hearing matters, or whether it's appropriate to admit those into the evidentiary record. I will just note right now that because this is an administrative proceeding, hearsay evidence is allowed, generally speaking. There are some limitations on that, but this does vary from a court proceeding in that the strict rules of evidence do not apply. So generally speaking, hearsay evidence is admissible into the evidentiary record in these types of proceedings. Our goal, of course, is to get to the truth of the matter as efficiently as possible. So that is always at the forefront of my mind when considering making evidentiary rulings. At that point, depending on the degree of the factual disputes, if it's appropriate, I will consider rebuttal evidence. It may be that sometimes there's the initial go round is adequate, and we've really fleshed out the factual disagreements and presented evidence on that, and there's not much more to do. But I would consider an opportunity for rebuttal evidence if that were appropriate. So there will be a chance for both sides to ask for that at that time. And then generally, there's an opportunity for closing statements at the end. That's the chance for each party to summarize the evidence they presented, to summarize the evidence they presented in opposition to the other party, and to summarize any legal arguments related to your position. I think, as I've said, the hearing it's very important to me that everyone has a chance to present the evidence, make the arguments, and be heard. That's the purpose of the hearing itself, and that is the most important part of the process. Now, one question that came to my mind here is whether or not we want to allow for closing briefs. Closing briefs are an opportunity to submit in writing a summary of the evidence that was submitted and relate that evidence to your legal arguments. Mr. Emmerich, now that you have some involvement, I'm more inclined to allow for closing briefs because I think it might be helpful. I mean, it's almost always helpful for the hearing officer to have a written summary of each party's position, as you know. But that is one question I think that would be good to talk about today. So with that, I will go in the usual order. I'll turn first to Ms. Jidkoff to see if you have any questions and also any comments about closing brief issue. And then I'll turn to you, Mr. Steinberg and Mr. Emmerich. So Ms. Jidkoff, you have the floor.
Thank you. I don't have any questions about the submittal of a closing brief, but I do think there would be a benefit to allowing the parties to submit such brief.
Do you have any opinion on length? I know you're on the spot.
Not at this time. No, I don't have to submit.
Okay, thank you. Mr. Steinberg and Mr. Emmerich, I will let you decide who will speak first, but do you have any questions or comments on the closing brief issue or any of the other procedures I very summarily laid out? They're also laid out in the hearing notice as well.
I'll just make a brief statement. I think closing briefs can be very helpful, and it does give an opportunity to, present the case at closing, something that can be referred to later. So I would support that.
Yeah.
Lengthwise, 12 to 15 pages, I think would probably be adequate, but I'm flexible.
Thank you. That was something in that range was in my mind. I was going to look back at other similar proceedings and see what we've done. So, Mr. Steinberg, do you have anything else you would like to add, or any other questions about the process that I
procedurally, no, I don't have any questions.
Okay.
That's why Mr. Emmerich's here.
I am glad he's here.
Thank you.
I think at this point in the process, my next step is to turn to both parties to ask if you have anything else that you would like to discuss today. I know we have some decisions to make about the hearing officer and then the timing of the hearing. So that may affect, that could affect this process a fair amount. But I'll turn to you first, Ms. Jidkoff. Is there anything else we should talk about before we close today?
I do just have one additional question about the February 24th evidence deadline, and then 2 comments regarding the hearing notice.
Yes.
So the prosecution team is intending to submit its evidence and witness statements in advance in accordance with that February 24th date, or if that date changes, if the hearing date subsequently changes. However, I did want to clarify if the prosecution team is intending to prepare a PowerPoint presentation that summarizes the evidence that we're submitting. Should we also aim to submit that presentation by February 24th? I know it's an optional deadline, but it'd be good to know by when you would need that presentation.
I think given that this is an optional deadline, as long as you are, well, summarizing, if it's referring to testimony that you're submitting in writing, as long as it's true to that testimony, and which I'm sure it would, and summarizes the exhibits you've already submitted, I don't think you need to submit that in advance, given that it would be, I mean, it's optional anyway, but I think given that it would be a summary document, a summary presentation, and I can understand, given the deadlines, that it may be useful to submit the testimony and then prepare the presentation. I don't think that would be necessary. It would be helpful to receive the presentation in advance of the hearing, just for logistical reasons, so we can make sure that we can pull it up quickly when you need it. So.
Okay, that's helpful to know. Thank you.
I hope it was a little rambling, but I think that's right. Thank you. And for you, Mr. Steinberg and Mr. Emmerich, it is often quite helpful to have a PowerPoint presentation when witnesses testify. That can be helpful to the hearing officer and anyone else watching the hearing. It is entirely optional, but that is a common practice. So I think that was the discussion here. And if you were planning to submit testimony, written testimony in advance by the February 24th deadline, and then we're planning to summarize that testimony through a PowerPoint presentation, what I just indicated to Ms. Jidkoff is that I wouldn't necessarily expect that PowerPoint on February 24th, but it would be helpful to receive it before the hearing, before the morning of the hearing, so that we can be prepared to bring that up if you wanted to use it for any testimony of your witnesses. Does that make sense, Mr. Emmerich?
Yeah, I think that works. That sounds acceptable. I'll
Okay.
talk to Matt a bit more about that, but I agree.
Thank you. Ms. Jidkoff, back to you. I think you may have had something else that you wanted to raise or ask.
Yes, thank you. I just had 2 comments on the notice of public hearing, just to make sure everybody is aware of the same issues that should be addressed. On page 3, item 1A, I believe there's an additional number in the code section that's cited. It lists section 11.66.555, and I believe that should only be 11.6.555. So it appears there's an additional 6, just to make sure everyone's discussing the same code section.
Thank you. I very much appreciate that. And what I will do, and you may be about to tell me another correction, but what I'll plan to do is issue an amended or corrected hearing notice to reflect that change, because that is important. These hearing issues are the issues that are going to be addressed during the hearing and would be addressed in any order, proposed order coming out of this hearing. So I appreciate that detail. It's very important. So that's how I will respond to that. But do you have another one for me, please?
Yes, this one is regarding the service list, in case that list is being used to pull the email addresses from. I did want to note that there is a typo in Bhupinder Sahoda's email address. There's a T following the B that should not be in the email address.
Thank you. I see that. I'm not sure if we may or may not have already corrected that.
Okay.
Thank you. We will, on the note of the service list, thank you for bringing that to my attention. After I've received, the AHO's received information from Mr. Emmerich and others on behalf of Mr. Steinberg about their contact information and if they want to be added to the service list. What we will plan to do on our end is to develop an updated service list, and that service list, typically what we do is we keep it as a Word document that is available on the AHO FTP site so that everyone, all the parties have access to it and have access to the most recent and updated version of the service list. So we will prepare that as soon as we receive those emails, and we will I will make sure this this typo is corrected if it has. I think we may have already corrected it. So thank you.
Okay.
Is there anything else, Ms. Jidkoff?
Nothing further for me.
Thank you. I appreciate that. I will look to you, Mr. Steinberg and Mr. Emmerich. Is there anything else that you would like to discuss today procedurally before we adjourn?
Did the, this is Matthew Emmerich, did the notice, was I correct that the notice is allowing for policy statements? Is that correct in this hearing or not?
Yes, Mr. Emmerich, if the notice does allow for policy statements by interested persons. So if there are individuals who would like to present a non-evidentiary statement, normally I would accept those. I actually normally do them before I hear opening statements from the parties. I will look to the room and see if there's anyone who is there and who is prepared to present a policy statement. Those who want to present a policy statement, they may do so orally at the hearing. It's also permissible to send those in writing in advance of the hearing, and we would include those. They would not be part of the evidentiary record, but would be part of the administrative record for the proceeding. So that is another option. Of course, the third option is to submit something both in writing and to appear at the hearing and make an oral statement. That is also acceptable.
Thank you.
Thank you. Are there any other questions, Mr. Emmerich or Mr. Steinberg?
Matt Emmerich, did you want to talk about continuance or not at this time?
Well, I think let's discuss. I think the hearing officer has given us some information that may necessitate a request for a continuance, or which the state board may in fact continue it on its own. But I think we should discuss that probably offline.
Thank you.
And Mr. Emmerich, the best, once you have, you know how to reach the AHO, is send us an email and in writing. That's the way to file documents with us if you were to make any type of request related to the process, the procedure. And if appropriate, you can also request an additional pre-hearing conference or other conference so that we can all meet and discuss the issues as you see fit.
Thank you.
Mr. Steinberg, is there anything else you would like to raise today?
No, thank you. Thank you for the opportunity.
Thank you. And I want to thank all of you for joining us today. I think I'm pleased we scheduled this pre-hearing conference. I think it was very important to hear from everyone. You can expect to see a corrected hearing notice from me, but I wanted to say that hearing notice will probably come out. That won't reflect my decision on whether or not to reassign this matter to another hearing officer or to postpone the hearing. I just want to make sure that we have a correct version of the hearing issues based on this hearing notice. Once I have heard from you, Mr. Emmerich, and given the prosecution team an opportunity to respond to anything that you have proposed, then I will, as quickly and timely as possible, issue a decision about whether or not I will continue to participate as the hearing officer so that we can all make plans as to how to move forward and when this hearing will actually take place. In the meantime, I encourage the parties to continue talking to each other and continue those settlement discussions. With that, I think we can adjourn for the day. So thank you very much. I really appreciate everyone's participation and your respectful cooperation. And for today, we are adjourned. Have a good afternoon. Thank you.
Thank you.